Hi everybody, Lawyer Autumn Whitboyd here with your most recent installment in our series on all things legal for online course creators. I am going to be diving deep into some copyright and trademark issues today. We're going to be talking about if you are wanting to use other people's stuff, other people's intellectual property in your online course or on your website, in your marketing materials, in a webinar, in any part of your online business. How does that work? Do you need to get permission? What is fair use? We're going to dive into all of the details of using other people's copyrighted or trademarked materials in your business. So definitely stay tuned if you have questions about that. I get a lot of questions about this and about fair use when I am doing my own masterclasses or talking to new business owners. So I think that you will learn a lot today. I'm going to start with my standard disclaimer, which is that I am a lawyer, but I'm not your lawyer. Please treat all of this as just information. It is not meant to be legal advice. If you have specific questions about your business or some type of use that you want to make of someone else's intellectual property in your business, definitely consult with a lawyer, whether it's me or someone else, to make sure you get the right advice for your own business. And I will say, this is definitely not an area that you want to DIY. There are some things in legal that I think are fine, especially if you're just getting started, for you to try to do on your own. But using other people's works in your business is a really, really dangerous, treacherous, tricky area. And so if you are thinking about doing this, especially if you have a business with significant assets or significant revenue streams, you are definitely going to want to consult with a lawyer to make sure you're doing things the right way. It is definitely not for the faint of heart. All right, we are going to dive in, and I have a bunch of examples to go over with you today that I think that you will find interesting as we go through this. So my number one tip, if you are thinking about using someone else's intellectual property in your online course or in your business, in your marketing materials, on your website, is don't. I know, I try not to be a negative Nelly. I try to help people find ways to do the things that they want rather than just telling them no. But this is an area where if you want the simplest, cleanest, easiest advice that I have to give you, it is to create your own intellectual property. So let's say you have, for example, I have a friend who has a travel business. So let's say you are leading trips and doing all of these, going to destinations around the world. The best bet, the safest bet, is to take your own photos and use them on your website, or take your own videos or hire people to create them for you. We talked a little bit in a previous episode about working with independent contractors to create things for you. So go back and listen to that if you have questions. You want to make sure that you own the rights in things that you're hiring people to create for you. But the safest bet is always going to be to either create it yourself or hire someone to create it for you, so that you know it's yours, you know that you've got the rights, you know it's clear. There can be no questions later. That is always going to be the safest bet. Now, the next safest bet would be to get a license. And so we'll talk about that in a minute. That is called getting permission or getting a license. I get a lot of questions, so I'm just going to touch on briefly what's called the public domain. A lot of people do think that they may be able to use images or video or music that's in the public domain as a way to kind of get free, not having to pay a license fee or reach out to someone as a way to get free stuff to use in their course. I will tell you, public domain is a little bit tricky because our copyright laws have changed over the years. And I should preface this with public domain only applies to copyrighted works. And just as a very brief primer, copyright is going to protect most of the things that I've been talking about, creative works like movies, photos, music, book, anything you think of as a creative work is going to be protected by copyright. What is protected by trademark are things like brand names, logos, things that you use to identify a company or the source of a product. So think about like Coca-Cola or McDonald's or Disney. They're typically going to be those well-known names, product names or company names, slogans, logos, things we associate with a brand more than, a creative work. So it's a little different. When we're talking about the public domain, there is no real public domain for trademarks. So public domain is really only applying to copyrights. Because there have been several different copyright laws over the last 100 or so years, different works, depending on when they were first created, first published, first put out into the world, or maybe not at all, they are going to have different terms of copyright. So figuring out whether something is actually in the public domain or not is not a simple thing to do. I can tell you the one bright line rule is that if something was published prior to 1923, so this is some pretty old stuff, photos, songs, I don't know that there were movies prior to 1923, maybe some really, really old grainy ones, then that is definitely in the public domain. There is no work that was first published prior to 1923 that is still in copyright protection. So you are definitely safe for really, really old stuff. Otherwise, it can be tricky to figure out. I'm going to put a link in the show notes, and so that'll show up on your podcast player. That is a very helpful site by Cornell University where it gives you a chart to help you figure out, depending on what year something was published and some other facts, whether it's likely to be in the public domain or not. But it's not, again, it's not a simple analysis for anything after 1923. And you may have heard recently there was a lawsuit about the song Happy Birthday, which was believed to have still been in copyright protection. And there was a recent ruling that it is in the public domain. So, and that lawsuit went on for years and years, and there was tons of evidence and arguing about whether it was in the public domain or not. So if you are intending on relying on something being in the public domain, I would say my advice to you, if you are my client, would be make sure it's published prior to 1923, or don't necessarily assume that it is in the public domain. There can be a lot of trickiness there. So public domain is one option. I would say it's kind of going to be one step down from my safest bet, number one recommendation, which is create your own stuff. Number two, rely on the public domain. Number three, if you didn't create it and you're not certain that it's in the public domain, then it is protected by copyright law. There's really kind of no two ways about it. Even if there's no copyright notice, even if nobody has put something on their website saying, no, all rights reserved, whether they've done anything at all to protect it, copyright in the United States, and I should say everything I'm talking about today is based on United States law, copyright protection in the United States is automatic. So as soon as you create a work, like we've all got smartphones now, and actually this video that I'm recording right now and this audio with the podcast, I'm creating a work that is copyrighted the second that it is out of my mouth and onto, it has to be what's called a tangible medium of expression, which includes a computer file, a piece of paper, a videotape, anything. It can't just be in your brain. It has to be out into some sort of medium, but it is automatically protected. So all those images on your smartphone, all the files on your computer are automatically protected by copyright. So whether you realize it or not, you have created a bunch of copyrighted material, and so has everyone else. So if you are looking for an image, let's use my friend with the travel website example again. If you are looking for an image of Paris to put on your website and you haven't been to Paris yet, you want to do a trip, but you haven't been there yet, so you haven't created your own photos, I cannot strongly enough tell you, please do not go on a Google image search and type in, images of Paris and right click and save them to your computer. That is very, very easy way to accidentally infringe someone else's copyrights and end up getting a cease and desist letter after there are robots now that will troll the internet and will go after, they will try and match up images that are in their database to people who've used them without permission. So using people's images or music or film or anything else without their permission is typically going to be copyright infringement. So my third best way of using other people's works the right way is to ask. So to get permission to either buy a license, if it's something like a photo, or let's say you like you listen to my podcast, you probably heard some music at the beginning. I paid a license fee for that music, and it's what's called a royalty-free license, so I can use it as much as I want. There's not a lot of restrictions on it. It was fairly inexpensive. There's lots of ways that you can buy a license to use images, video, music in your business. I would caution you, make sure you're getting the right license, because often if you're using it commercially or in a business, they will want to charge you a little bit more. But make sure that whatever use you want to make of it matches the license term. And that is a very safe way to make sure that you have the correct permission. If any questions come up later, you should keep that license in your file. So keep the email or download a copy of the license if you're buying it from a website, and make sure you keep a copy of it, so that if any questions come up later, you're able to refer back to it to say, on X date, I paid $12, and stock images are really not very expensive either. So, and there's now a lot of stock subscription sites, so there's lots of good ways to get stock images for not a lot of money. So please, 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 again, do not be using the Google image search to find images for your website or your marketing materials or your online course. It's just very dangerous. And I will tell you, actually one of my clients got wrapped up in, it's almost like a scheme or like a bait and switch. There are companies now out there who basically create images that they know people are looking for. So they create stock images. In my client's example, it was some Scrabble tiles that spelled out a word, and he used it on a blog post. So it was Scrabble tiles that were related to the subject of his blog post. So this company had created these images. They had registered them with the Copyright Office. And once you have registered an image with the Copyright Office, you are able to get up to $150,000 for an infringement in damages, plus your attorney's fees. So if you are registering your copyrights early, which these stock photography agencies are doing, now you are able to go out and go after people who are using them without permission. And he did have to pay, he did not pay $150,000. If you get a letter from one of these stock photography agencies, just know that the price may be negotiable. But he did have to pay some money, or they would have sued him. And so that's what happens. You get a cease and desist letter, they will threaten to sue you, and if you don't pay, they may actually sue you if they think you're a worthwhile target, that they can actually get some real money out of your company. So it's a big, big risk if you are using images that you're just finding on the internet that you don't know. And I will say this guy actually, it looked like it was a free photo site, so I will also caution you. I think a lot of people use these free stock photo websites like Startup Stock, and there are a couple others. I'm not going to drop the links in the show notes because I don't recommend them, because sometimes images will end up there that aren't really free, that someone really owns, and someone copied and pasted them onto that free stock photo site without their permission, and so you could still get in trouble with that. So I do not recommend ever using free stock images either. Your safest bet is to actually get a license or sign up for a subscription site or somewhere where you know you have real solid permission to use the images, and it's not going to come back to bite you later. Because I will say, although my client did not pay $150,000 per image, often they will ask for several $1,000s per image. And just that, let's say you use 3 or 4 images without permission, that can rack up really quickly into a lot of money. So it is definitely a risk that I think is not worth taking. So you want to, number 3 option is to ask for permission, preferably finding some stock or getting a license. If it's a famous photo you want to use, a lot of those are listed with the stock agencies, and you may have to pay a little bit more for it, but if it's a really specific image you need, you can get it at a reasonable price, and you will know that you have solid permission. I will say for things that aren't necessarily, you don't want a stock image, you really want to use someone's image. So let's say you follow someone on Instagram who's an interior decorator, and you write about interior design. So you want to use an example of something they have posted. So it's a room design, or it's some photos of a process that you admire, and you want to post them either on your blog or use them in your online course as an example, or maybe just post to your social media. So the same thing applies. Your best bet is going to be to ask for permission. And I think this scares a lot of people, or it makes people nervous, but I will tell you it is easier than you think. It can be as simple as sending someone a DM or shooting them an email and just saying, hey, I really admire your work. I would love to share it. Do you mind? And let me know how I can give you credit or how I can say thank you. And I will say 99% of the time, people are flattered. They are delighted. They are happy to, get their work in front of a new audience. And so they will almost always say yes. Very occasionally, they may ask you to pay them something, and then at that point, you can decide, is it worth it or not? Often they will want a particular kind of credit, or they'll say, yes, please include my website, or yes, please point them here to this particular thing, or please tell them about this. And that is just, it's a kind thing to do. But if you are just pulling images off of someone else's social media or someone else's blog or someone else's website and putting it on your social media or your blog or your website or in your online course, and you haven't reached out to them, you have not talked to them, you've not gotten permission, that is almost certainly going to be copyright infringement, because they own the copyrights, they created it, and you did not have permission. So now you are a copyright infringer. And if they find out, they could A, be very angry, and B, they could send you a cease and desist letter. C, if you can't, come to some sort of agreement about how to move forward, they could file a lawsuit against you for copyright infringement. Now, filing a lawsuit against you for copyright infringement is pretty unlikely if it's someone who's not in the business of creating stock photos. Like the example that I gave earlier with the Scrabble tiles, that was a company that their whole business is creating stock photos and going after people who use them without permission. It is very expensive to file a copyright infringement lawsuit. We're talking probably $10,000 to $20,000 to just get started and kind of get the ball rolling. So it's not something that anyone will take lightly. But if the other person has registered the copyright and they know that they could sue you, they have a large dollar amount that they could get from you for damages and their attorney's fees. If you lose, that's pretty threatening, and you're probably going to pay them some money to keep them from doing that. So we don't want you to end up in that situation. People could also, this is not really legal, but, could badmouth you, could say what a terrible person you are, could kind of start to ruin your reputation publicly, which is a whole other issue. If you're using people's work without permission, people don't like it. It doesn't feel good. Even if it is putting your work out in front of someone new, if you don't have the choice of kind of controlling how you're credited or what information about you is included when your work is shared, it feels like a violation. And so it is always going to be the best thing to do, to reach out, do it very nicely, and 99% of the time, people will say yes. And in that 1% where someone says no and they don't want you to use their stuff, great. Now and if you had, it probably would have been ugly, and so you have avoided that whole issue by just reaching out and asking, quickly for permission. I will say, if you are wanting to use a more famous work, like an excerpt from a well-known book or movie or music, that can be a little trickier, and I'm not going to lie, you may have to work through an agency, you may have to pay more money, it may be a little trickier to track down who owns the rights or who, if it's an author who died, is their family now the person to contact, or if it's a company, who's the right person to contact. It can take a little legwork, but especially with those well-known works, if you are doing something publicly with it, it can get really ugly really quickly if you are not getting the right permissions. So, and if you have a popular online course, you do not want to receive a cease and desist letter that means you have to take down your course, or you don't want them to go to your course platform like to Kajabi or Teachable or Thinkific and file a copyright infringement notice against you, which shuts down your whole course. That is also very bad. That's probably even almost as bad or maybe even worse than being sued if your course gets taken down because of a copyright infringement notice. So all this to say, getting permission is my number 3 piece of advice on how to use other people's works the right way. Now, I get a lot of questions about using other people's stuff on social media. So Instagram, Facebook, Pinterest, YouTube. There are so many platforms now, Snapchat. I will say, treat it no differently than anything else we've been talking about. So I know people feel like it's different than if you put it in a newspaper or if you put it on your blog or on your personal website, but it is no different. It is just a different platform. It is still copyright infringement if you are posting someone else's photo or video or other content without their permission. So giving credit or posting a link is not going to get around that. It is not good enough. If someone is upset that you posted their work without permission, they can file a takedown notice against you, they can send you a cease and desist letter, and they can sue you. So it opens this whole Pandora's box of bad things that you do not want to happen to you. So social media, posting without people's permission can still be an issue. I'll give I have 3 quick examples of this. This dates back to 2015, so I've been watching this for several years. I'm recording this in August 2019, so 4 years later. You may have heard of photographer, or I guess he's really more an artist, Richard Price. There was a lawsuit filed in 2015. He went on Instagram and basically, I think, took screenshots of other people's Instagram posts, and he blew them up into very large, either canvases or I'm not sure exactly what the medium was, but he did an art gallery show that were basically just other people's Instagram images and their screen name, blown up and put on the wall at an art gallery. And in some of them, he added a little comment below it, or he made a tiny little change, but not really any big transformative change, which we'll talk about in a minute with fair use. He basically just copied people's photos off of Instagram and put them up in an art gallery. And several of the people whose photos he chose have sued him. That suit was filed in 2015. It is still pending 4 years later. So he has said he has a fair use defense. He is arguing. He's kind of at the forefront of fair use. He tries to push the boundaries. He's been sued before and he has won in prior lawsuits. But this one is, he's done much less to the photos. He's done much less alteration, or he hasn't really added much of his own creativity to them. He pretty much just slapped them up on the wall in an art gallery. So that suit is still pending in August 2019. He is arguing fair use, but fair use is a defense. It is not a prevention from getting sued. So it will not stop someone from suing you. It may stop them from winning, but here's how it works. They will sue you, and then you will tell the court, no, it's not infringement because it was fair use. And then you, the person who used their work without getting permission, you have what's called the burden of proof. You have to show that it was actually fair use, that it checks all the boxes. So that lawsuit is still pending. Two other recent social media lawsuits, a new trend in 2019. A lot of paparazzi are disappointed that with social media being so rampant, newspapers are not paying as much for their images. They're the ones who stake out restaurants and clubs and things, trying to snap images of celebrities. And the demand for their images has gone way down because now everyone has a cell phone, and anyone can snap a photo and put it up on social media. And the celebrities themselves are posting so much more about their own lives. So it's become much less of a commodity. So what has happened is a lot of celebrities will repost pictures of themselves that paparazzi take on their own social media feeds. And the paparazzi have started suing them for doing this. So two examples, Gigi Hadid, who is a supermodel, influencer, celebrity. She posted an image of herself that was taken by paparazzi. That lawsuit was dismissed. The photographer sued her for copyright infringement. It was dismissed, but on a technicality. So it's not because it was fair use or anything like that. There's been a change in copyright law about when you have to register before you file a lawsuit. I will not bore you with all those details. But that lawsuit, if the photographer had taken all the right steps, would probably still be going. So that's a valid copyright claim. Even a photo of yourself that someone else takes, they own the copyright in that. Ariana Grande also posted a picture of herself. There was a new lawsuit filed just this summer, and it settled. So I'm assuming that she probably paid the photographer some money. We never know, but usually lawsuits don't settle without somebody paying something. So that was certainly probably a huge hassle for her, and definitely not something that you want to find yourself in the middle of. So for a long time, I used to say back in 2014, 2015, that this is kind of the wild, wild west of social media. We don't really know if people are going to start going after people for posting things without permission on social media. But I can say in 2019, that is no longer the case. People are starting to go after social media users for copyright infringement. It is becoming much more common. So it's still somewhat new, but definitely not unheard of at this point. So my takeaway for you from social media use is it is no different from using it anywhere else. If you are posting images on your Facebook feed or your Instagram feed or in stories or on YouTube, just know that can be copyright infringement. It does not change it just because you are on a social media platform. All right, so let's dig into fair use. I get many, many, many questions about this. So the first thing I want to mention is that I hear a lot that people say, oh, well, if I change 10% of a photo, then it's fair use. Or if I only use 5% of a song, it's fine. There is no magic percentage. Fair use is actually written into our copyright law. It's in part of the law that was passed in the 1970s, so it is old. There is no percentage in the fair use section. Here's what I will tell you about fair use. There are 4 factors that are listed in the law, and a court that is evaluating, again, it will be in the context of a lawsuit. You will get sued, and then you will have to argue to the court that your use falls in this fair use category, and so it's not violating anyone's rights. There's 4 factors that are listed in the law, and then there's kind of a free-for-all. The court can kind of consider whatever else it wants. And these cases, I will tell you, are all over the map. So I highly, highly recommend that if you have a business where you're wanting to use other people's work in a product you sell, in a course, or in your marketing as a key part of your business strategy, you definitely want to consult with a lawyer because you want to get some good analysis and good advice on whether your use is likely to fit in this fair use category or not. And even then, it is not a slam dunk. That I have seen cases that I thought were crazy that turned out to be fair use, and I've seen others that I thought there's no way, and then it went the other way. So you just never know. It kind of depends on what one judge or one jury decides. So here are the 4 factors that a court is going to look at. The first one is whether your use is for profit. So if you are using someone else's work in a business setting, that's going to kind of weigh against finding fair use. If you're using it for a nonprofit use or education or some betterment of the society, that's going to be more likely to be found fair use. So, and we kind of, you call balls and strikes on these. So is this more likely to be fair use or less likely? But again, there's no magic number, there's no magic percentage. You could have 3 factors in your favor and another one against, and that factor could be, kind of rule the day. The second factor is, what is the type of work that you copied? So we're looking at the work that you are using that is not your work. Is it super creative? Is it something like a beautiful photograph or a painting or a novel? Or is it something that's a little bit more factual? So there's lots of things in our businesses that are protected by copyright, things like employee manuals, and if you have a process or procedures list that you use, or if you have worksheets that you use with your clients. There's all these things that, yes, they are protected by copyright, they are creative, but they're not super creative. It's not like a movie. It's not the things that we think about as really, really artsy or creative things. The more artsy or creative the thing that you're copying is, again, the less likely it is to be fair use. If you're copying something that is predominantly factual, like let's say a passage from the encyclopedia or business worksheets, process manuals, those kinds of things, that is going to be more likely to be found to be fair use, just because we kind of consider there's a sliding scale of protection in our copyright law, and things that are super creative are more highly protective. Things that are more factual or more less creative are not protected quite as high. Again, you can see just in hearing these first 2 factors, where you fit on this spectrum can be really different depending on what you're using and how you're using it. So this is always going to be a really individualized analysis. I can never give you like a bright line rule to say, if you do this, you're fine. If you do that, you're not. It's always going to have to look at all the context. All right, the third factor that we're going to look at is how much of that original work, the one you copied, how much did you take? So we're going to look at how big is the work. Is it a very large painting and you just took a little corner of it? Is it a 5,000 page treatise on something, or a very large novel and you only took a page? Or is it a 4-line poem and you copied 3 lines? Or is it a photograph and you copied the whole thing? Is it a 2-minute video and you copied 1 minute and 30 seconds? So this is kind of a proportionality test. So how big or what is the original work comprised of, and how much of it did you take? And again, the more you take of a very small work, that doesn't look so great. If you're taking a very small amount of a very large work, that is going to look a little better. So again, very individualized depending on both the work that you copied and the use that you're making of it. So the court will also look at what use did you make of it. So again, let's say you have an online course that's 12 modules, and each module is, has 4 lessons, and they're each 10 to 15 minutes long. So we've got a lot of content, and if what you took only comprises 30 seconds in one of those lessons, again, we're looking at proportionality here. That's a very small part of your course compared to the course as a whole. So we're going to look at both how much did you copy and kind of how does it fit in the bigger picture of whatever product you're selling. If you have a website, as the contrary, and the website is just 1 page and the whole thing is an image that you took from someone without permission, again, that's not going to look great because you're using the whole thing and your use of it is, dominated by that, the use of that other work. All right, and then the last thing that we're going to look at is, what is the value of the original work, or what is the effect of your use on the market for that original work? So this especially comes into play with things like stock photographs, where there's a very established market. There's very consistent pricing for how much you're going to pay for different kinds of stock photographs, especially if you could have purchased a license to use the photograph and you just chose not to. Then that's going to look like you're basically making a replacement for you just decided not to pay, but you're replacing the market basically by your use. You are kind of stealing their revenues. You're stealing money that they would have charged you. There are other things where maybe the value is not clear, or it's not very valuable, sometimes here we'll look at, do they refuse to let anyone use it? Sometimes that will come into play. If someone really doesn't want their work used by other people. that may come into play in this analysis. So I will say there are a couple of types of uses. We have all these factors, but I can't give you any bright line rules, but I will say there are some types of uses that are very commonly found to be fair use, and those are parody. So like if you are making fun of another song or making fun of a movie in your use. And so you have to reference that original work for yours to make sense. You can't do a parody without referencing the original work. It just doesn't work that way. Another very commonly approved use of someone else's work is if you're doing like a book review or if you're doing commentary about a movie, you have to reference some of the work. Again, for your review to make sense, you have to either show a snippet or talk about it or maybe use an excerpt from the book if it's a book review to kind of give a feel for the flavor of the book. Commentary is almost always going to be found to be a fair use. Again, weighing these other factors. So if you're doing a book review and you publish a whole chapter of the book, that probably is not going to look great. But if you're just pulling a paragraph so that people can see, a sense for the style or the writing, or if you're doing a movie review and you pull a snippet, one short scene or a little bit of dialogue, again, that is probably going to be found to be fair use. But again, this is not a bright line area. So questions that I get a lot are, what if I have an online course and I want to use a snippet of a movie because it's really funny and it illustrates my point? And I will say, run through this fair use analysis, but if you could have gotten a license for it, which you probably can if it's a commercially available movie, you are selling your course, these fair use factors do not look great, even if it is a small excerpt and your course is much larger. The movie studios do not look kindly on use without their permission. And now there are robots on a lot of the platforms, certainly on YouTube, that will recognize movies or songs and they will shut you down immediately. So something that I do recommend sometimes, though, is if you are wanting to use a snippet of a movie or a song or something that is well-known commercially, is rather than copying and incorporating the actual clip or the actual song into your online course or onto your website, is to include a link so that people can visit that scene or that song on another platform where the copyright owner has posted it. So there's tons of movie clips posted legitimately on YouTube that the movie studios have approved, or like Saturday Night Live skits, tons of them, and they're posted by Saturday Night Live because they want people to watch. So you can include a link, and you're just, at that point, you're kind of like giving directions. You're not infringing someone else's work because you're just showing people how to get to a legitimate place to see the clip or to hear the song. So that is always going to be fine. You're just sending people somewhere else. You are not actually copying and pasting the work into your online course or into your marketing. So that is always going to be okay. I will say you've always got to do your own kind of risk-benefit analysis here. And this is, again, why it is really helpful to speak with a lawyer as you're working through these issues, because so much of fair use and so much of legal in general is deciding what is the risk that someone, I hate to say this in a way that makes it seem like you're skirting the law, but people break laws every day and not everybody gets caught. So you've got to decide how public is your use, how likely are you to actually be damaging the market for the product or the copyrighted work that you're using in your course or in your marketing materials. If it's inside your course, if it's a pretty small course, if you're using it in a group program, if you're giving a lecture for 30 people at a community center, these are all pretty low risk activities, very low risk that you're going to be found out, very low risk that a movie studio or another content owner would ever come after you. So I don't say that to encourage you to infringe other people's copyrights. I really do think that just being able to sleep well at night and not have to worry about someone coming after you is very valuable. But I am a very risk-averse person, and I know not everyone is. So you have to consider what is your risk tolerance as you are looking through these issues, because you may decide, yes, I could get a license, but it's going to be very expensive and it's going to be hard to track down, and I'm using it in a very small way, and you may decide that you're willing to take that risk, that someone could send you a cease and desist letter or do a takedown notice and come after you, and you're willing to accept that risk with your eyes wide open because you think it's a fairly low risk. So that is always going to be your choice. Now we've been talking about copyrights, and now I want to switch gears a little bit and talk about trademarks, because the law is a little bit different, and we don't see this quite as much, or I don't get quite as many questions about this, but I do want to touch on trademarks and fair use. So with trademarks, or I should back up, with copyrights, you infringe just by using someone else's work without permission. So it doesn't really matter if someone would have thought that you were associated with the film or the music or the photo, or was confused. It doesn't really matter how you used it. Use without permission is copyright infringement, point blank. It's what's called a strict liability. With trademarks, you can use someone else's trademarks in certain scenarios and not be infringing their trademarks, because trademark law is all about, does the use that you're making of the trademark confuse potential customers? So it really is a totally different analysis when you're looking at using someone else's trademark in your business. You have to look at, does this confuse people who are looking for X product and instead they find my product? So you're going to look at, is it the same type of service or product? We do have similar trademarks that can coexist because they're in very different areas. So think about Delta Faucet and Delta Airlines. Same trademark, the word Delta. They're both registered, but they're totally different products and services. Airline versus faucets and plumbing fixtures. So there's no risk of customer confusion. If they were selling similar products, now we have a problem. So here are some examples of the ways that I see people using other trademarks in their online courses or online businesses. Probably the most popular one that I see is people who are doing courses that teach how to use a platform or how to use a software. So there's lots of very common courses about how to use Instagram, or courses about how to use project management software like Trello or Asana in your business. If you have the product name in your course name, that could be an issue because you are using someone else's trademark basically to advertise your course, to get people interested in your course. So that can be a problem. Also, I sometimes see this with movie or book titles or popular characters. I also see people sometimes using quotes or song lyrics. That's more typically within your course, not as the name of your course or the name of your business. But all of these can be problematic if you are using it in a way that makes it look like you are somehow associated with the trademark owner, or that you are sponsored by them or endorsed by them. That can be very tricky. And I will say sometimes trademark owners can be aggressive with their rights. So even if you're not necessarily using it in a way that would be confusing, maybe you're kind of borderline. This is another area you probably are going to want to talk to an attorney, but sometimes the trademark owners will be aggressive in enforcing their rights and will send a takedown notice or will send a cease and desist letter. And because it's usually David and Goliath, usually, Instagram or Facebook, that it's a huge company. You don't want to go up against them. They have tons of lawyers and virtually unlimited resources. So most people will just cave because it's not worth the fight. There was a big kerfuffle recently about Entrepreneur Magazine, who has trademarked the word entrepreneur. And they have been sending cease and desist letters to people who use the word entrepreneur in their business name, which I think is a total overreach. It goes way beyond what they're actually doing. But they have the resources, they can be aggressive, and it's very expensive for you to defend yourself if you find you're back up against the wall and Entrepreneur Magazine is coming after you. So just be aware. If you are using a popular product or service name or a book title, book character, quotes, song lyrics, these can be issues if you're using them in your product name or company name, especially with online courses. These are very easily searchable on the web, and so that's how people are patrolling for trademark infringement. So you will probably be found, and it can be an issue. There is a fair use doctrine under trademarks, but it's totally different than the one that we just talked about with copyrights. So typically with trademarks, what fair use allows you to do is to talk about someone else's product or service in a way that does not imply that you're associated with them, but you are allowed to talk about them because there are some products that you can really only talk about by using the brand name. So you can always, this is called nominative fair use, it's a big mouthful, but you can always use someone else's product name in comparing your product to someone else. So if you want to say your product is better or faster or it does XYZ in a different way compared to this product, you can use that product name. So example, I'm just sitting here. I have one of my favorite things, my Tervis tumbler with my law firm logo on it. So if you, for example, were making your own insulated cup and you wanted to say it keeps drinks colder, 2 hours longer than a Tervis tumbler, because Tervis tumbler is, I'm looking, I see a little R in a circle, so that is a registered trademark. You could use that. That's comparative fair use. Now you have to be careful and be sure that you might want to include a disclaimer that says, I'm not endorsed by Tervis tumbler, or you might have to include some facts about how you did your tests. There might be some other rules that you get into, but using someone else's product name as a comparison to yours is typically going to be allowed as long as you're following all these other rules. You can also use other people's trademarks as a way of saying that your product is compatible with them. So we all, you may not, but I love Apple products. So I have an Apple computer, I have an iPhone, my husband has an iPad. We have all kinds of things that are not produced by Apple, but are compatible with our Apple devices. So saying that a charger, for example, is compatible with Apple products, or saying that a phone case will fit the iPhone 10, that is typically going to be allowed. Again, you want to be clear, all these other things that I just mentioned, not implying that you have been sponsored by Apple or that they have approved your products in any way, but just saying they are compatible, that it will work with Apple products. That is typically allowed. Again, parody is going to come into play here. So if you're doing a parody, let's say about Apple products, you are allowed to reference their trademarks as part of your parody. And then again, similar to the copyright fair use, typically you're allowed to use trademarks in things like academic articles, media reports, things like that are typically going to be okay. The other type of fair use that we have under trademark law is what's called descriptive fair use. And that is going to be where you have a trademark that is kind of it's not a word that's a made up word. It is a word that has a meaning. And it's a descriptive word. So let's say if there were, or there is, a company called Honest. They make all kinds of products. So, and they don't make products that have anything really to do with honesty. They make cleaning supplies and makeup and skincare and all kinds of that kind of stuff. If I want to use the word honest in a sentence because it has a meaning, I can use the word honest in a sentence. That's what descriptive fair use is. So if someone has trademarked a word that actually has just a regular meaning, they cannot stop you from using it in a sentence. So you can't use it as a trademark. I can't name my company Honest if I'm selling things that are going to be confused with their products. That's used as a trademark, but I can use it just as a regular word. So if that makes sense, I can use it as a descriptive word if it's a descriptive trademark. This won't come into play with things like Xerox or Kodak or, all these weird words like I mentioned Asana and Trello earlier. Those are made up words. They don't have a meaning. So descriptive fair use will not apply to them. But I can use regular words that just happen to be a trademark in a sentence. That is allowed. All right, I know this was a deep dive and I went long today, so I appreciate it if you stuck with me to the end. I hope this was helpful. Next week, I am going to be featuring an interview with Laura Belgray. So you may have heard of her. She has, her brand is called Talking Shrimp. She is probably the top copywriter in the online world right now. She's worked with Marie Forleo and tons of other superstar online course creators. So I cannot wait to share my interview with you. She has a lot of insight both about things legal and just online business. So you are really going to enjoy that. I hope you have a great rest of your week and I will talk with you soon.